All right, let's go to the next case, Castano versus State. Incidentally, I forgot to mention to the last participants that if you want me to remind you of time remaining for rebuttal, I'll be happy to do so. Although it's on the clock. All right, are you ready?
Yes, Your Honor. May it please the Court, my name is H. Manny Hernandez, and I represent the appellant in this case, CLAUDIA VERGARA. I would ask to reserve about 2 minutes for rebuttal, and ask that the Court, if you could warn me, I'd appreciate it. I also file supplemental authority, and I trust that the Court got it. And then finally, before I begin, I have read the Keith case, and I cited it in my brief. This case involves an appeal from a denial of a 3.850 alleging ineffective assistance of counsel.
Let me ask you first about the claim that does not make sense to me, and that is the failure to advise about the added condition at the last minute that the defendant comply with DCF regulations. I failed to see any prejudice there in that if she wasn't going to operate a facility, she wouldn't have been subject to those regulations, and if she was, she would have to comply with them anyway. So I'm struggling to see what you believe the prejudice would be for the addition of that.
I struggle with that too, and the prejudice after much thought is if she didn't comply with DCF regulations, she'd normally lose her license.
Right.
There might be some administrative consequences. When you make it a part of probation, and she violates them, now she's got a violation of probation, and the judge can throw her back to put her in jail if he wants to. So that was made at the last minute a condition of her probation. And as a result, she was prejudiced. Because if she didn't violate, if the judge chose to, now the judge may feel that be unreasonable.
Right.
But that was certainly one of the consequences. And from the record, it's quite clear that her trial attorney didn't really address it with her, didn't object when it was thrown in at the last minute.
What's the prejudice, though?
I'm sorry?
What's the prejudice in this case?
In this case?
I mean,
that she's on probation and has that condition, and if she did violate, and I think, as a matter of fact...
But we're not here because she violated that.
No.
No. So...
Well, I'm just answering Judge Wilson's question, Judge.
The point is she could have some jail time because of a violation of...
Right, and it just goes into, again, the argument that her trial counsel was ineffective and was not meeting up to snuff, I guess, or meeting the minimum standard as a criminal defense attorney in representing her at this change of plea and negotiating the plea. The DCF was there, and it was actually the Henry case where they actually remanded because of a last-minute addition to a plea agreement, and they thought that significant enough to remand it.
So let's get to the main issue. Now, I read that the court, during its colloquy, specifically asked Ms. Castano if she was aware that as a result of the plea, he said, if you're not a U.S. citizen, you can be deported as a result of this plea. He didn't say you may be deported. He said you can be deported. How does that square with Padilla?
Well, to me, can means may. It doesn't mean that you will be deported. And the distinction is made quite clear in Hernandez's decision by the third DCA, which goes a different direction than the fourth DCA in Flores.
And we've had a panel that cited to Flores, correct? Approvingly. I mean, we've affirmed based on Flores.
In the Chin case, there was a one-word decision affirmed citing Flores.
Wouldn't that mean it would take an en banc decision from our court not to follow Flores at this point? I
don't believe that a one-word opinion PCA citing Flores without knowing the facts, I don't believe it would. To the extent that it did, once again, the Supreme Court's Padilla decision, I think, would supersede what the Flores decision said. I don't think it does. I don't think a PCA citing one case would necessarily bind the panel of this court. I could be wrong on that, and to the extent that it does, then I guess I'll have an opportunity to seek rehearing.
Even under Hernandez, though, you wouldn't be entitled, your client wouldn't be entitled to relief because Hernandez, applying wit, found that it was not retroactive.
Yes, and again, Your Honor, first, Hernandez parted company with the fourth DCA on the application, and specifically found that just the warning of it may, can, and again, I don't mean to be splitting hairs, but can and may and will, I respectfully submit, are different. And Padilla, as the Supreme Court of Florida, in Pert and in Green, made
But the statute that you've given to us in your notice of supplemental authority says any alien who at any time after admission is convicted of a crime of domestic violence, blah, 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 child neglect, is deportable. That doesn't say will be deported, it says is deportable. Why isn't that the same as saying can be deported?
I'm not an immigration lawyer, Judge. My understanding of that statute is that lists every crime that means you're going to be deported.
You have to have an order of the AG before that happens. I mean, it is not a you're going to be. There has to be. It just gives the AG authority to deport you. So you see what I'm struggling with here?
It's mandatory. It's my understanding under 1227, it is mandatory if you're convicted of felony child neglect, you will be deported. Every alien
let me ask if
is
this
deported
way,
has to have an order of the AG. I apologize, Judge.
is child neglect an aggravated felony under 8 U.S.C. 1227A2A3?
I don't know. It's listed in that particular, I believe it is.
I thought it was listed under 2B. I mean, because Padilla involved an aggravated felony, and the United States Supreme Court said, well, if it's an aggravated felony, it's an automatic deportation, and every defense lawyer ought to know that. There are plenty of cases where the deportation consequences are not clear, but in this one, where it's an aggravated felony, they are clear. And then in Hernandez, the third seemed to say, it doesn't matter whether it's aggravated or not, which doesn't make sense to me. I mean, not being an immigration lawyer, it seems like there are a lot of cases where the kind of warning that, reading Padilla, it would seem like there are a lot of cases where the kind of warning that the trial judge gave would be perfectly adequate under Padilla, and the exception would be an aggravated felony, which means automatic deportation, and there you got to tell them you are going to be deported. I mean, that's the way I read Padilla, but...
My understanding, again, from I'm not an immigration lawyer, but I do represent a lot of people in this situation. There are different ways to get deported. Aggravated felony is one of them. Crime of moral turpitude is another one. The statute's listed in 1227, which lists domestic violence offenses, including child neglect. Felony child neglect is another way to get deported. That statute, as I read it, specifically says she is deportable. Okay, she's going to get deported, unless there's some change in the law. She's subject to getting deported.
Subject to deportation and automatic deportation because of an aggravated felony, in reading Padilla, seem to be two different things.
Well, and this is the problem in this entire area, and this is why it's so important, I guess, that this court kind of flush it out to assist all the trial judges and attorneys as well. There are more than aggravated felonies as a basis for deportation.
Sure.
This statute, I believe, says, in my position, without being an immigration lawyer, is that she's going to be deported. There's no ifs, ands, or buts based on this conviction. Absent getting this set aside or some other, executive decision for some reason, she will be deported based on this particular conviction. That's something that the trial counsel should have known. And this isn't a he said, she said, where the facts say, she says, he didn't tell me, and she said that he did tell her. When you read the transcript, and the court will be patient with me for a moment.
Let me just read this from Padilla. There undoubtedly will be numerous situations in which the deportation consequences of a particular plea are unclear or uncertain, and the duty of private practitioner in such a case is more limited. When the law is not succinct and straightforward, as in many scenarios, a criminal defense attorney need do no more than advise a non-citizen client that pending charges may carry a risk of adverse immigration consequences. And the concern, I have is it's certainly not clear to me that child neglect is a case that's going to result in certain deportation, which is what the Padilla court was saying about a trafficking drug offense. That's an aggravated felony, and under the law, that is certain deportation, and anybody ought to know that. I don't know why they think anybody ought to know that, but
I wouldn't know.
Yeah, but that's what the majority said, and they are the Supreme Court.
Well, look, and as a criminal defense lawyer, this Padilla case, as I'm sitting here today, obviously it's my godsend, but as someone who has to make these decisions,
right.
It is difficult. And you almost have to be a specialist in immigration law to know. Padilla says when it's clear. Under 1227, I believe it is clear, and with the court's permission, I didn't give it to you in the supplemental authority. There is one BIA, which is the Board of Immigration Appeals, which I believe says 1227 and child neglect is automatic deportation or deportable.
You ought to file that as a supplement.
Yes, I will, Your Honor. I do have it. Her immigration lawyer sent it to me, and for some reason I failed to include it in my supplemental authority. So, but again, it's not a he said, she said, and I'd just like to read his advice from the transcript at page 56 from the hearing.
We all read that. I think we're clear on what the advice was. Go talk to an immigration lawyer. You know, it could have consequences. We know what the trial judge said. What about WIT? Did the fourth DCA get it wrong in its retroactivity analysis? Because that would be a problem for your client as well.
It would be a very big problem if it's not retroactive, and I would respectfully submit, yes, they did get it wrong. It was the third DCA. The fourth DCA was Flores.
Right, I'm sorry. Yeah.
The third DCA in Hernandez basically found that the final prong of the requirement that constitutes a development of fundamental significance didn't apply. They then went to the Chandler analysis, the Florida Supreme Court in Chandler, and said that the purpose to be served is by the new rule. They had to look at that, and they found it to be more ministerial, more not a fundamental difference. And I respectfully submit that, you know, Padilla goes right to the heart of effective assistance of counsel. He talks about Strickland. This goes back to Gideon, the right to counsel. All the other rights are enforced through counsel. If you don't have effective counsel, you can have all the rights in the world. If your counsel doesn't know what he or she is doing, it's meaningless. So effective assistance of counsel in terms of the order of rights, I would respectfully submit, is if not first, right up there. Second, it goes right to the integrity of the entire process. The voluntariness and knowledge of the plea. Is it a voluntary and knowing plea? She said, and the testimony was clear, that she didn't know that these consequences. Based on 1227 in that case, which I hope to get to you, she is facing deportation because of this.
She said as I understood it, she said, I didn't know I could be deported if I entered this plea. I mean, it's clear the trial judge told her that. And she said, yes. I mean, it couldn't be any clearer to me. You can be deported.
This goes to the heart of what has to be done and why I respectfully request. And am I 3 minutes in addition to this, or am I?
You got 2:46 left. You asked me to warn you at 2 minutes.
Okay. It goes to the heart of what this issue is. Hernandez specifically found that just telling the normal 3172C8 you may get deported is no longer enough in a case where there is mandatory deportation.
Okay.
It's not constitutional. And they reversed their own decision in Bermudez, which was the case that the fourth DCA relied on to make its decision. And the fourth DCA also got wrong in distinguishing Padilla from their case by saying that in Kentucky, they didn't have similar warnings. But the Supreme Court, at footnote 15 of the Padilla decision, specifically says Kentucky has the same warnings, or very similar warnings that Florida has. So that there is no significant difference there. So I believe that the third DCA did get it wrong in terms of the significance. I just can't imagine what other rights are more significant than having effective assistance of counsel and ensuring that any guilty plea is knowing. The case law, which is cited in the brief, is quite clear on that. Going back again through Gideon, to Strickland, to Santabello, right through to Padilla and Green and Pert. I ask that the court reverse and remand the case so that she be allowed to withdraw her plea and proceed with competent counsel.
I know you're running out of time, but let me ask this. There's a line of cases, I think the Florida Supreme Court case of Green is one of them, that talk about prejudice in this context, that you have to actually, in order to make this kind of claim, you have to face deportation, or there's something you have to allege, and it's... That was
the question, and the DCAs were in conflict
right.
Before Green. Green made it clear you don't actually have to show that the person is in deportation. Okay. The Florida Supreme Court said in Green, you just have to show that they're subject to deportation, and you can proceed under the ineffective assistance of counsel, the PERT type of motion. If there's an adverse ruling, given Flores and given Hernandez, I just urge the court to write an opinion on this. a PCA citing Hernandez or Flores, and frankly, you're going to have to decide one way or the other,
Right.
Hernandez or Flores, helps no one. And in this state, in this country, and in this state, and in this district, dozens, if not hundreds, of aliens are pleading guilty every day before judges. They need the guidance of this court. I, as a criminal defense attorney, need the guidance of the court, and I believe the state needs the guidance of the court. What is required? Hernandez is quite clear. The rule no longer is constitutional if it's mandatory. And this court, I believe, has to write and clarify what has to be done. So I'd ask that, and that you certify the question as a question of great public importance, and that there is a conflict amongst the districts.
Counsel, you're out of time. I'll give you another minute in rebuttal.
Thank you very much, Your Honor.
May it please the Court, my name is Bonnie Parrish. I represent the state of Florida in this case. It's the state's position that this particular case, on the facts of this case, an evidentiary hearing was held. The judge made a credibility determination. She denied the motion. She found the attorney was the more credible witness in doing that, and that finding is supported by the transcript.
Right, but you recognize that the advice that you could be subject to deportation or may or might or can is insufficient under Padilla if the crime is one that would result in a clear deportation or certain deportation, correct?
The advice from counsel, yes.
Well, counsel or the judge, whoever it comes from.
I don't think Padilla applies to the warning given by the trial judge. Padilla is an ineffective assistance of counsel case.
Right.
A case, Padilla...
But if it's a circumstance under which Padilla would require the lawyer to advise the client that he or she will be deported,
right.
I don't see how a statement from a judge that you might be deported would be sufficient to cure that.
If it's mandatory deportation,
right.
you may be correct about that.
Okay. And so the question I have and what I'm struggling with is it seems like the third DCA in Hernandez is saying that this category of offense under 8 U.S.C. 1227A2B, even though it's not an aggravated felony, still is one of those felonies that results in automatic deportation or for which the kind of warning that Padilla says you have to give for an aggravated felony applies. And that...
Well, in Padilla, the court gave no warning. And in Padilla, the defense attorney told Mr. Padilla that because he had lived in the United States for 40 years,
right, it was a
he wasn't going to be...
Right.
Right. It had nothing to do with what the warning...
It seems pretty clear to me that the law laid down by the Supreme Court's majority opinion went beyond what would be necessary to have decided that case. I mean, it seems like they said that you've got to tell them that they will be deported if that's...
The attorney has to tell them. Right. They don't go into what the trial judge has to tell them.
Right.
It's not...
But the attorney didn't tell her that here.
The attorney told her that the government was actively, aggressively seeking to deport people who were convicted of felonies. I'm not sure how that's not telling her she's going to be deported. If you have to have a will, I mean, who knows if she's going to be deported? I wish I was an immigration expert. I don't know if this is mandatory. I can't figure it out. I look at one thing and it's not.
None of us know whether this is one of the clear cases would suggest to me that maybe it's not one of the clear cases.
Right, and maybe that is what it suggests.
What does deportable mean in 8 U.S.C.A. 1227? Does deportable mean you will be deported, or does deportable mean that there's some other step that has to occur first?
Well, there's other steps that have to, I mean, you don't just, I don't believe they just come and pick you up and put you on a plane and send you back home. I believe there's a process that you go through. But, is deportable, to me, is the same. We're going back, the may, can, and will. Is deportable mean you will be deportable? There's no question you're leaving the country. That's the end of the discussion.
Well, let me just propose this as a hypothetical. If we get supplemental authority that says that this offense means automatic deportation, then what would your argument be? My
argument would be that wasn't presented to the trial judge. And this court can't consider that at this point in time. Well, they didn't. They made just nothing more than a bald allegation.
That's not a factual issue.
That's a law question.
That's a legal issue.
Yeah.
We can consider that.
I would still say he gave her an adequate warning under Padilla. The attorney did. He did what he was supposed to do. He told her they were at his words.
Your argument is that if in Padilla, where you had an aggravated felony that meant automatic deportation, if the lawyer said, well, you can be deported and the United States government's actively pursuing the deportation of anybody who's committed a felony, that would have been an adequate warning in that
I believe that would have been an adequate warning under Padilla. He would have known that he was facing deportation. If he doesn't work for ICE, none of us know who's going to be deported and who's not. Telling him that that's what he's facing, I think that would have been enough in that case. He told him he didn't need to worry about it because he'd lived here for so long.
Right.
And that was the end of the discussion. The judge gave no warning. I guess the Kentucky plea form has that you could be deported. But no warning was given. In this case, the judge gave the warning. She indicated that she understood that. And at the evidentiary hearing, the attorney testified they discussed it and that he told her they were actively, aggressively seeking deportation. I don't know what more he could have told her. You will be deported? I mean, if they're aggressively seeking deportation on felonies, to me, that means you will be deported. So even applying Padilla to this case, the facts are sufficient here.
Are you suggesting that Padilla should be applied?
No, I'm suggesting it shouldn't be applied. It should not be
retroactive. I'm asking about the Witt analysis.
No, I think
the Witt analysis is appropriate, and that's sort of one little issue that the third left out there is that the Padilla case suggests that it's going to be applied retroactively, but when you go through the Witt analysis, they find that all three factors indicated that it would not be a retroactive application. One of the big factors being that it would cause a major upheaval in the administration of justice because there are a lot of pleas that would be set aside.
Well, absolutely. But I think the other thing is that in Florida, we've given this warning for so long. We've made defendants aware that they could be deported.
Right, but I think you've conceded that if in a Padilla case where it's automatic that may be deported, at least from the lawyer, wouldn't be sufficient advice.
May be deported from the lawyer under Padilla, that would appear not to be sufficient advice.
And so again, I don't know how the judge telling you the same thing would cure the lawyer's failure. I mean, we've always assumed, I think we've always assumed in Florida that the law is that as long as you're aware that it might result in deportation, that's all the advice the lawyer would have to give. So the judge gives that advice that would cure any problem. And now Padilla says, no, that's
right. But if you have a judge giving you may be deported, and you have the lawyer saying, you will be deported.
Well, if the lawyer says you will be deported, that would end the...
Right. Well, if you read the testimony that he gave, I think that you'll see that he did he use the word will? No, he didn't use the word will, but he basically told her they were actively deporting for felony convictions. She did not want to go to trial. He testified to that over and over during the evidentiary hearing. Padilla should not be retroactively applied. The third correctly decided that. I think other parts of their opinion are incorrect. I don't think that that Padilla has, found that our warning is now constitutionally deficient under Padilla, but they did correctly find that it shouldn't be retroactively applied. And I'd ask that you affirm the order denying the motion for post-conviction relief. Thank you.
Let me ask you one more question. How can we figure out, as a matter of law, what category of offenses are supposed to be those that are clear? Because in reading Padilla, it's not clear to me what's supposed to be clear yet. The Supreme Court thinks that they're...
The aggravated felony, I thought I printed out that statute, and I couldn't find it in my pile of papers over there. In Flores, they cite to the statute where the definition of what an aggravated felony is. Clearly, the aggravated felonies, there's mandatory deportation. I think trafficking falls underneath that.
That's what it says in Padilla, yeah.
So this case is not an aggravated felony. This case doesn't fall within the definition of that.
Can't imagine how child neglect would be an aggravated felony.
No, really.
Well, especially on the facts of this case.
But did you, I mean, in Hernandez, they sort of jumped over that because it didn't look like Hernandez involved an aggravated felony either, but they said this other category of things that are deportable, we're going to apply Padilla to, as I read Hernandez.
My reading of Hernandez was, that's a drug case as well, that it was
a trafficking case.
That did fall within the aggravated felony. That did fall within that. In Flores, that's part of the distinguishing of Padilla from in Flores, is that involved an aggravated felony. And they cite the statute for the definition. I know it's subsection 43.
I'm looking at Hernandez. It says Flores' conviction was not an aggravated felony. It came under 8 U.S.C. 1227A2A.
Right, Flores.
No, 2B, which is the same. I mean, if you look at the supplemental authority, that's the same section here.
Right.
And in Hernandez, they say, under our reading of Padilla, constitutionally effective defense counsel is required under either scenario to furnish the will subject to you and not the may subject to you warning to the client. And it's talking about the same subsection that this crime is under in looking at the notice of supplemental authority.
I disagree with their reading of Padilla on that. I mean, Padilla to me it's very fact specific. It's one of those. It's an aggravated felony.
You recognize that their holding goes way beyond. I mean, they could have
I do.
The attorney gives this advice, then yeah.
I do recognize that. I do recognize that. But I think that Hernandez, even though they found that it should not be retroactively applied, I think they pushed Padilla beyond what Padilla pushed itself beyond. It's an ineffectiveness case. That's what it's not. It didn't address what the proper kind of warning. It addressed what the attorney, to be an effective counsel, what the attorney needs to say. And I think Hernandez, the beginning part of that opinion, I think they made it even broader than it is. And I agree with you. It's out there.
Yeah. Okay. Thank you.
All right. Let's see. We'll let you have one more minute.
Thank you, I appreciate it. Padilla is quite clear. I believe they rejected the floodgate argument, the concern that was discussed by the third DCA in Hernandez, and I think it's quite clear that they did address this as if it should be applied retroactive, and I'm not sure how the third DCA got around the Supreme Court ruling. I believe Supreme Court decisions are binding. If you go to 1227, none of us are immigration lawyers, but it's not just aggravated felonies. 1227-2, which I've cited the court to, starts criminal offenses, general crimes. Then it talks about crimes of moral turpitude. That's deportable. Multiple criminal convictions. You may have misdemeanors. If you have multiple, you can still be deported.
Well, Hernandez says that the will subject to you warning is required for crimes under A2B, which is what this crime falls under. So
I just want the court to understand it's just not aggravated felonies.
Right. Well, that's what Hernandez says anyway. I mean, we were debating whether that's correct because that's not necessarily what Padilla seems to say. But
the law has changed since the trial judge ruled in this particular case. Padilla was decided. She didn't have the benefit of Padilla back when she issued her order.
Let me ask you to address one more thing, and I know your time's running out, but will you address the argument that the advice given in this case is comparable to or sufficient to meet the will subject you to deportation?
I'm sorry, I didn't understand. Can you say that again?
Yeah, the argument was by saying you're committing a felony that can get you deported and they're actively pursuing deportation of all felonies, that was the equivalent of saying what Padilla required, which is you're going to be deported.
That's not what Mr. Torreira said. If you read it again, and you didn't let me read it, but when you go to that particular page, what he says is, I've heard from people I know that they're actively, aggressively deporting, and you need to talk to an immigration lawyer because I'm not an immigration lawyer. He didn't give her any advice. He gave her gossip and said, go talk to an immigration lawyer. That clearly falls below the standard of Padilla in this particular case. Just because you say, well, they're deporting a lot of people, you need to go talk to an immigration lawyer, that's not giving any advice whatsoever. And then again, under the Hernandez...
It at least sounds like it's saying that you're likely to be deported. You need to check this out. There's a substantial risk of deportation.
And Padilla says that if in fact she is deportable, and I believe on the 1227 in the case I'm going to provide she is, it was his duty to meet the effective assistance of counsel standard to tell her, you are going to be deported, and let her make a knowing and intelligent decision. This goes directly to guilt or innocence, to the very integrity of our entire system. So once again, I ask that the court reverse, and should you rule against Ms. Vergara, I strongly urge the court to write an opinion on this, because I think that the Florida Supreme Court would welcome your input, as they are ultimately the ones who are going to decide what we have to do. And I admit this is, what the judges have to do.
Counsel, your time's over.
Thank you.
Thank you very much.
All right, we'll adjourn for the day.